Emergency board. This is under the from the revised corporation code, in which when can there be an emergency board? When the vacancy in the office of the director or trustee prevents the remaining directors from constituting a quorum. It means to say no more quorum already. Um, there can be no majority. So the statute a quorum and an emergency action is required to prevent. These are the three circumstances for the emergency board to be constituted. When there is to prevent grave, substantial, and irreparable loss or damage to the corporation. The vacancy may be temporarily filled from among the officers of the corporation by unanimous vote of the remaining directors or trustees. Again, there will be an emergency board to be constituted in order to prevent grave, substantial, and irreparable loss or damage to the corporation. So, how is that? Example, when there is already two remaining directors and three vacant director positions. Again, two remaining directors and three vacant director positions. So therefore, these two directors cannot anymore constitute a quorum, no more majority vote. So therefore, the corporate officers such as the treasurer, it is a non-director, and also the corporate secretary, also a non-director, shall, in a unanimous vote of the remaining directors. How is that? How is that? The action by the designated director or trustee shall be limited to the emergency action necessary. So again, when there are already two remaining directors and three vacant director positions, it shall be occupied by the corporate officers. Corporate officers already, by particularly by the treasurer and by the corporate secretary. They will be considered as designated director or trustee. Again, in an example, two remaining directors and three vacant director positions, the corporate officers such as the treasurer and corporate secretary, these are not directors, they shall occupy and shall be considered as designated director or trustee. Then, the action by the designated director or trustee shall be limited to the emergency action necessary, and the term shall cease within a reasonable time from the termination of the emergency or upon the election of the replacement director or trustee, whichever comes earlier. So, again, there will be an emergency board in order to prevent grave, substantial, and irreparable loss or damage to the corporation. And at the same time, there is no more quorum. There is only two remaining directors, and it requires to constitute a quorum because there is a need of unanimous vote of the remaining directors. So the limitation only for this emergency board, their purpose is only limited to the emergency action, to make an emergency action, and their term shall cease, shall stop within the reasonable time from the termination of the emergency. When the emergency has already been resolved, therefore these designated directors and trustees shall be already replaced by elected director, or upon cease or upon the resolution of the emergency, these designated directors will go back to their positions such as treasurers and corporate secretaries, and they will be replaced by an election, replacement of a director or a trustee through an election from a meeting called for the purpose. So again, for an emergency board, there will be an emergency board in order to solve in order to make a risk emergency action to prevent grave, substantial, and irreparable loss or damage to the corporation. And the board of directors are not anymore constituting a quorum because there are only two remaining directors, and So therefore, it will have a designated directors and trustees from the corporate levels. These are treasurers and the treasurer and the corporate secretary. So this time, let's go with the compensation of directors and trustees under Section 29. In the absence of any provisions in the bylaws fixing the compensation, in the absence, if there is no provision, if there is no stipulation in the bylaws or articles of incorporation fixing or about the compensation of these directors and trustees, they shall not receive any compensation such as directors or trustees except for reasonable per dimes. So as a general rule, if there is an absence of any provisions fixing the compensation of directors and trustees, they shall not receive any compensation. As an exemption, they will receive a reasonable per dimes. These reasonable paradigms provided, however, that such any compensation other than the paradigms may be granted to directors by vote of the stockholders represent at least a majority of the outstanding capital or majority of the members at a regular or special meeting called for the purpose. Again, as a general rule, these directors and trustees shall not receive any compensation in the absence of a provision or any provisions in the bylaws. They will just only receive a reasonable per dimes. Only, that's the general rule. If there is no stipulation or if there is an absent of any provisions in the bylaws regarding or fixing the compensation of the directors and trustees, they shall not be given a compensation but only a reasonable per dimes. However, if there is a grant of compensation to these directors and trustees, the compensations may be granted other than the per dimes if there is a vote, if there is a vote of the stockholders represent at least majority of the outstanding capital stock or majority of the members at a regular or special meeting called for the purpose. So aside from the reasonable per dimes, these directors or trustees shall receive compensation provided there is a majority vote of the stockholders representing at least majority. There is a vote of the stockholders representing at least majority of the outstanding capital stock. Again, vote from the stockholders representing at least majority of the outstanding capital stock or majority of the members in case of non-stock corporation at a regular or special meeting called for the purpose. In no case shall the total yearly compensation of directors exceed 10% of the net income before income tax of the corporation during the preceding year. So again, that's another limitation. If these directors and trustees be granted a compensation, it shall be limited only to 10%. 10% of the net income. So net income before income tax of the corporation during the preceding year. Not the compensation shall be given to these directors and trustees shall not exceed 10% of the net income. Next, as a continuation, directors or trustees shall not participate in the determination of their own per dimes or compensation. So therefore, it is only between or among stockholders representing at least majority of the outstanding capital stocks in or among members in a non-stock corporations. It is only among them. They will meet, they will agree if they will be giving a compensation to these directors or trustees. Corporations vested with public interest shall submit to their shareholders and the commission, which is the Securities and Exchange Commission, an an annual report of the total compensation of each of their directors or trustees. Again, corporations vested with public interests. What are these corporations vested with public interests? These are banks, quasi-bankings, other financial intermediaries, non-stock saving loans, associations, di ba? Pawn shops, um, shall submit to their shareholders and the commission, submit to the shareholders a report and also to the Securities and Exchange Commission an annual report, um, the total compensation, about the total compensation of each of their directors or trustees. Liability of directors, trustees, or officers under Section 30. Directors liable for unlawful or fraudulent acts. Again, directors liable for unlawful or fraudulent acts. Liable jointly and severally for damages arising from lawful acts. If there is the phrase jointly and severally, it means to say solidarily liability. Solidarily liability. Jointly and severally. So directors shall be liable jointly and severally for damages arising from from unlawful acts, gross negligence, or bad faith in directing the affairs of the corporation, or acquire personal or pecuniary interest in conflict with their duties to the prejudice of the corporation, stockholders, members, even other person. So it means to say directors prioritize their own interest, which is conflicting to the interests of the corporation, shareholders, and members. They shall be liable for that. Again, directors liable for unlawful or fraudulent acts. So solidarily liability for paying damages to the corporation or acquiring um, oh, damages arising from unlawful acts, gross negligence, or in bad faith, directing the affairs of the corporation. It means to say inconsistent, not in accordance with what is to be or what is the duty or what is intended for the corporation, or inconsistent with the objective of the corporation, and that or such director acquire personal or pecuniary interest in conflict with their duties to the prejudice there is prejudice to the corporation, shareholders, members, even other persons. So again, the directors shall be liable jointly and severally from their unlawful acts or acquiring personal or pecuniary interest in conflict with their duties to the and cause prejudice to the corporation, shareholders, and members. Directors' liability for secret profits. So that the first is that directors shall be liable for unlawful acts or fraudulent acts. Now, directors' liability for secret profits. Directors and officers are fiduciary representatives. It means to say they are entrusted. They are entrusted with trust by the shareholders and members. They are fiduciary representatives, and such are not allowed to obtain or retain a commission, bonus, gifts, or any personal profit or advantage on the side or on other official acts as in connection with purchase, sale, lease, loan, or contract by the corporation. The said director, trustee, or officer shall be liable as a trustee for the corporation and must account for the profits which otherwise would have accrued to the corporation. So this is already a kickback. Directors, trustees, or corporate officers are earning kickback from sale, lease, loan, or contract entered into by the corporation. So those are secret profits and they are liable for that if proven. Again, directors and officers are fiduciary representatives and are not allowed to obtain or retain a commission, bonus, or gifts or any other personal profit or advantage on the side or on their official acts, diba? Even on their official acts in connection with purchase, sale, lease, loan, or contract by the corporation, they obtain a kickback, diba? From the purchase of the corporation, with the sale of the corporation, leased by the corporation, loaned by the corporation, and entered contract by the corporation. They receive kickback, bonus, gifts, personal profit. So therefore, if proven, these directors shall be liable. Next, um, dealings of directors, trustees, or officers with the corporation. This is under section 31. Contract of directors with corporation. Again, contract of directors with corporation. The law allows dealing by directors, trustees, or officers or their spouses and relatives within the fourth civil degree of consanguinity or affinity with the corporation of which he is part of the board. If all the conditions set forth in Section 31 are complied with, otherwise it is avoidable at the option of such corporation. Again, as a general rule, um, directors may contract with the corporation where he belongs, diba? The director may contract with the corporation where he belongs. The law allows the dealing by the directors, trustees, or officers or their spouses and relatives within the fourth civil degree of consanguinity or affinity with the corporation of which is part of the board. So it means to say the director may enter into a contract with the corporation in which he belongs. Not just only the director himself or the trustee himself or the corporate officers, but also including their spouses and those relatives within the fourth civil degree of consanguinity. They may contract with the corporation, provided the following conditions set forth in Section 31. These must be complied with, otherwise it's voidable at the option of such corporation. What do you mean by the ball again? Valid until annulled. But it may be ratified, diba? It may be corrected or approved. So, what are those conditions for a valid contract? First, the presence of such director or trustee in the board meeting in which the contract was approved was not necessary to constitute a quorum for such meeting. Again, this is the very first requirement in order to have a valid contract of a director, trustee, or corporate officers or their relatives or spouses to contract with the corporation which they belong. There must be the presence of such director or trustee in the board meeting in which the contract was approved was not necessary to constitute a quorum for such meeting. So, provided these directors, trustees must be present in approving the contract to be entered by the corporation with their relatives or with themselves, diba? They must be present. And it must not necessarily to constitute a quorum for such meeting. There is no need for quorum already, provided the presence of the directors or trustees or the corporate officers or their relatives must be present during the board meeting during the approval of the contract. Next, the vote of such director or trustee was not necessary for the approval of the contract. So that is why from the very first, diba, the first requirement is that the presence uh, was not necessary to constitute a quorum. They are not anymore, they are not part of the quorum. They are not a part of the quorum because the vote of such director trustee was not necessary for the approval of the contract. That is why they are not anymore necessary to constitute a quorum. Mm-mm. Their presence is mandated, mandatory. They must appear during the board meeting, but their vote was not necessary for the approval of the contract. Third, the contract is fair and reasonable under the circumstances. Fair and reasonable under the circumstances. Fourth, in case of corporations vested with public interest, these are banks, quasi-banks, and other financial intermediaries, non-stock loan saving, loan associations, pawn shops, diba? So, in case of corporations vested with public interest, material contracts are approved by at least two-thirds of the entire membership of the board, with at least a majority of the independent directors voting to approve the material contract. So when it comes in cases of corporations vested with public interest, there is a need of at least two-third of vote of the entire or um, material contracts. Diba? These are material contracts. Material contracts are approved at least two-thirds of the entire membership of the board. So it means to say 0.66 of the entire, so two-thirds of it, or with at least a majority of the independent directors voting to out. So therefore, at least two-thirds of the entire membership approval. Again, the fourth requirement is that in case of corporations vested with interest, at least two-third of the entire membership, two-third of the entire membership of the board, with the second one is that with at least majority of the independent directors voting to approve the material contract. Two-thirds of the entire membership and majority vote of the independent directors. Next, the last is that in case of an officer, corporate officer, the contract has been previously authorized by the board of directors. So, in case of corporate officers who will be entering a contract with the corporation where he or she belongs, the contract must be the contract has been previously authorized by the board of directors. That's the fifth. So these are the requirements that needs to be complied. These are the requirements that need to be complied by the director, officer, or trustee, or their spouse or relatives within the fourth civil degree, um, consanguinity or affinity, if they will enter contract with the corporation which they belong. So first, the presence. There must be a presence of that director or trustee or that officer in a board meeting, and they are not necessary to constitute as a quorum, but the vote of these directors, officers, trustee sh- shall not be necessary for the approval of the contract, and provided that contract is fair and reasonable under the circumstances, corporation will benefit from it, diba? And in case of vested corporations, banks, quasi-bankings, and other financial intermediaries, it requires at least two-thirds of the entire. It requires a vote of it requires a an approval vote. It requires an approval vote of at least two-thirds of the entire membership, with at least majority of the independent board of directors to approve the contract, to approve the material contract. And when it comes to in case of an officer, the contract has been previously authorized by the board of directors. In addition, when any of the first three conditions set forth in the preceding paragraph, or when any of the first three conditions set forth in the preceding paragraph is absent. So, what are these three set conditions? The first three set conditions: the presence, board of directors was not necessary, and the contract must be fair. When any of the first three conditions set forth in the preceding paragraph is absent, In case of a contract with a director or trustee, such contract may be ratified by a vote of stockholders representing at least two-thirds of the outstanding capital stock or at least two-thirds of the members in a meeting called for the purpose, provided that full disclosure of the adverse interests of the directors or trustees involved is made at such meeting and the contract is fair and reasonable under the circumstances. So again, when the first three conditions, where any of the first three conditions set forth in the preceding paragraph of section 31 is absent, therefore, it may be ratified. It may be ratified by at a vote of, diba? In case of director or trustee, such contract may be ratified by a vote of the stockholders representing two-thirds of the outstanding capital stock or at least two-thirds of the members in the meeting called for the purpose. Can be ratified, di ba? When any of the first three conditions is absent, it may be ratified by at least two-thirds of the outstanding capital stocks or at least two-thirds of the members um, in a meeting. That is in the case of directors or trustees. But aside, other than them, it will not be granted. Contracts between corporations with interlocking directors. So we will discuss this in the next.